Hi, I'm Tom Marks with the Marks Law Firm, and welcome to the Healthy Family Law Attorney. So, I have a new question today from a viewer. They ask, every time I need to communicate with my ex, they are nasty and profane. Is there some way we can communicate that forces them to be civil? All right, this is a great question and a question I get quite a bit, so let's dive in. First, if you have minor children, you're going to have to communicate with your ex based on what the best interest of the minor children is, what their needs are, time sharing schedules, things like that. There are ways to minimize it, and we can talk about that. I will also say that if you don't have minor children together, and you simply have maybe an ongoing alimony requirement or an equitable distribution payment requirement, there's really very little need to have to communicate with that person. And if you do, you should limit it to written communication. So a good way to do that is first, require that all communication be in writing. That can either be text or email, or some type of written form of communication. That can be included in the marital settlement agreement. It can also be included in the parenting plan. So that's good to limit it to written communication. What's even better is to limit it to communication through an app like Our Family Wizard or some of these other apps. And here's why. Number one, they typically have a tone meter. I know Our Family Wizard has a tone meter that puts a warning up there if your ex says things that are inappropriate, profane, angry, things like that. So the tone meter is number one. Number two, the judge is going to read those emails, has access to Our Family Wizard. It can be also in the court order that the judge can do that. So it puts the other side on notice. It oftentimes makes them behave better because they know that it's going to be looked at by the judge. And third, that is clearly evidence that can be used in court later against your ex to seek sanctions or some type of relief from the court, which I'm going to talk to you about in a minute here. So you want to use an app if possible, but otherwise limit it to written communication. Okay, so the next step is seeking sanctions through the court. You can file a motion for contempt, a motion for sanctions, a motion for enforcement. There's a lot of different remedies that you can ask the court to impose. They can be anywhere from attorney's fees against your ex. Some judges will actually put the person in jail. Some judges say that putting someone in jail is the best way to give them an attitude adjustment. Nobody really wants to spend the night in jail. It's a sledgehammer that the judge has at their disposal to order if there's repeated violations or significant enough violations. So seeking sanctions is one. Okay, two, the court can actually restrict either the amount or the method of communication. So the judge can say, okay, I'm going to limit communication to only through Our Family Wizard. I'm going to limit it to one time a day or maybe only 2 times a week. And it has to be only related to issues involving the minor children. Can't be any other issues. If there's any kinds of threats, profanity, unnecessary accusations or something, the judge can take further sanctions at that point. There is the possibility, if the threats are significant enough, that you feel in fear for your safety, there's a reasonable fear, then you can seek to have a domestic violence injunction entered with regard to the communications. And that's probably the topic of another video, but that is certainly within the purview of what you are able to do if it rises to that level. I will say that it's really important that your attorney puts sufficient language in the parenting plan or the marital settlement agreement about non-disparagement, non-harassment. I've had to do letters to the other side with a cease and desist letter with regard to even third parties. So it may not even be your ex, it may be their new significant other that's engaging in it. So there are things your attorney can do, and there are things you can do. So feel empowered. Don't let this happen to you continuously. You can do things about this. The next step, I think, is to ask the court to appoint a parent coordinator. A parent coordinator under the statute is somebody appointed by the court to get involved in these types of disagreements between the parties, so that the court doesn't have to deal with them as much. The parent coordinator can't change the parenting plan or the time sharing schedule, but they can break ties on disagreements about perhaps the type of communication or the frequency of it, or those kinds of things, or scheduling with the children. So that's another option. And finally, I think if things are bad enough that there may actually be a personality disorder that your ex is dealing with, like narcissistic personality disorder, borderline personality disorder, histrionic personality disorder, whatever, you may want to ask the court to appoint a social investigator to do psychological evaluations of your ex. They may want to do a 360 and do a psychological evaluation of your ex, of you, and maybe of the children if the children are old enough. And then they put together a report and a recommendation to the court, and the court may restrict your ex's time sharing, communication. The court may impose requirements on your ex to attend batterers intervention classes or therapy or something of that nature. So feel empowered. I want you to know that I believe your family matters, and I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. I hope you found some value in this. Please hit that like and subscribe button. Leave a comment below. Love to receive questions like this so I can answer them for my audience. And with that, I'll say have a great week. Thanks. Bye.